Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today I have three guests. The first is Veronica Finkelstein. She is an associate professor of law at the very new Wilmington University School of Law. Also with us today is Nancy Rapoport. She is the UNLV Distinguished Professor and Garman Turner Gordon Professor of Law at the William S. Boyd School of Law, as well as an affiliate professor of business law and ethics at the Lee Business School. And last but not least, we have Burk, who since leaving practice in 2011 has taught at a number of law schools and continues to research and serve as an expert witness in the areas of legal ethics and professional conduct, and still does empirical study of the legal profession and the legal academy. So welcome.
Thank you.
Really delighted to have all three of you here, and especially at a time where I think, each year I think, oh, we're at a pivotal moment for legal ethics and professional conduct. And then there's a new moment, and it's another pivotal moment. But you all have been experts in professional conduct and legal ethics. And so let me start by asking, what is it that is front of mind right now in the area of legal ethics and professional conduct in our current moment?
Well, for me, it's the effect of artificial intelligence on everything related to the legal profession, which I think is going to trickle down into how law schools deal with the effect of AI on the legal profession. So that's what I'm obsessing with at the moment.
Well, you are right that law schools are going to have to deal with it, and we are already dealing with it, but it's going to only continue. And Veronica, what are your thoughts?
In addition to AI, one of the things that law schools are going to have to grapple with, in my opinion, is building PR into a holistic experiential understanding of how the rules play out. It does strike me that when I went to law school, professional responsibility as a class was all about preparing you to take the MPRE. And while that's certainly important, I think one of the reasons that we wrote this book was because we felt like it's also important to teach students how to grapple with difficult issues that may come up in practice. And I think that's going to be true in professional responsibility classes. It's going to be true in writing classes, that students are going to need to graduate from law school with more practical skills.
Well, thank you. And you have given us a great segue into the book. The three of you are authors of Ethical Lawyering, a Guide for the Well-Intentioned. Second edition just came out in February. And so you shared just now, Veronica, a little bit of why you all decided to write a book in ethical lawyering. And Bernie, maybe you can share with us what prompted you to get involved and why the book that you all wrote together is different than other professional responsibility books.
Sure, great question. What induced me to get involved in the book is Professor Rapoport, who is a longtime friend. What we all shared in common was a view that the 24 textbooks and casebooks in professional responsibility, all of which have many good qualities, but none of them felt like an optimally effective teaching tool, because professional responsibility is, and if you could take a legal realist point of view for a minute, it's what lawyers do and don't do. And so talking about professional responsibility as a philosophical issue or as a virtue, as the ethics issue, is extremely interesting, but it doesn't really address the multiple different risks and opportunities that actual practicing lawyers face. And let's face it, most of our students, virtually all of them, are going to be practicing lawyers. And the view we all shared was that the model rules are, for the most part, not that hard to understand, but they're devilishly difficult to apply in situations that most lawyers find themselves in. That's the way we structured the book.
I think that's a perfect description, that the rules themselves aren't difficult, but the application can sure be a challenge. And Nancy, tell us more about that.
Well, one of the fun things about teaching PR is that I get to start each semester with, this is the only course that's entirely about you, because it really is how they're going to become and stay professionals. And if you pitch it that way, doesn't matter which book, I want people to use ours, doesn't matter which book they use, but law students get much more interested when they realize this is about them.
If I can add something, I mean, my experience teaching PR is that was often a largely thankless task. People don't like that they have to take it, and it's often taught in a scoldy way. Don't lie, cheat, steal, which to the average person is actually pretty insulting because they already know that. And our book begins, no, you can't lie, cheat, or steal, but if you didn't know that already, then no book is going to help you.
That's why we called it Ethical Lawyering, a guide for the well-intentioned, because it's not the opposite ends of the spectrum that are easy to define when it comes to professional responsibility. Yeah, you don't sleep with clients unless you have a pre-existing relationship of some sort with them. Yeah, you don't steal. And yes, of course, you want to be the best advocate you possibly can. Of course, that end of the spectrum is easy to define too. It's the middle gray area. And just memorizing the rules or even getting through an exam on the rules doesn't really teach you how to make difficult decisions when you're actually in the moment living through them. And that's one thing that we tried to do a bit differently with our book. Is one of the things that is different is that we have characters in the book that are in different settings. One is at a large firm in a large city, one is at a public defender's office, and the hypotheticals and problems and scenarios that run through the book involve these characters. And they're all characters that students should be able to see themselves as not long after they graduate. So it's not like, what would the U.S. attorney do in this situation? Well, they're not going to be the U.S. attorney, I don't think, in the first or second year after graduation. What would a judge do? Instead, it's you're the clerk observing this happen with your judge. What are the ethical quandaries here? You're a first-year lawyer being asked to make this representation at a settlement conference. Should you or should you not? And so to tail on Bernie's point, we're trying to be realistic. We're trying to put them in the scenarios that are the gray area that are difficult, but we're also trying to make it realistic for students. So it is really, as Nancy says, about them. It's not about just memorizing the rules, but about being able to apply them in the kinds of quandaries that may come up in practice, especially when you're a young lawyer.
Well, and I was interested to see that there's not case law, that you haven't included case law, and instead it's just a problem-based course. So I'm sure that students appreciate that. I have one class without cases, right? Bernie?
Yeah. Especially because we're all people with a lot of practice experience, and we wrote all the problems on the basis of situations that we all have encountered in private practice, things that come up that get lawyers into trouble. We've also written the book in the second person. We talk to you about what your life is going to be like. And my experience, and I think Nancy's and Veronica's too, is that students at first find that startling and then they find it very engaging. My experience in teaching from the book is that suddenly there are a lot more people with their hands up. And what they say always begins, well, what if I? And getting the student into the driver's seat and looking for directions is a very striking change from my previous experience with other very good textbooks.
Yeah, and the only thing I would add to that is that it's also, I don't think law schools in general focus on statutory analysis as much as they could. Well, the rules you can teach in a statutory analysis way, which gives students additional skills in addition to letting them think about what kind of lawyers they're going to become.
That's a great point. And I taught professional responsibility for a really tragic semester. My prior law school. And boy, the students really, it's just not a course that students tend to enjoy. And they're there for the MPRE and because they're required to take it. So tell me a little bit about how do you address those students who are like, oh, I'm just here for the MPRE. I know that's not how you tailor the course, but obviously that's a reality that students face.
Well, I can start because I'm teaching it right now. I'm using our second edition right now and jotting down notes for our third edition. I think some of it is finding ways, in addition to having students identify with the characters in the book and with their struggles, finding ways to make the problems resonate with them. They start thinking after they answer the problem, well, what if this? And what if this? And what if this? And it's because they're summer clerking or they're working in law school and they're facing similar issues that are like, but not exactly identical to our problems. So once students start raising their own experiences, other other students react to them. And then it gets really exciting.
And you mentioned earlier, Nancy, that obviously one of the issues facing you as a professional responsibility scholar and all who are teaching ethical lawyering is artificial intelligence and other new technologies. So if you all will touch on how the book addresses those challenges and how you're addressing it in your teaching and what you expect we'll see in the legal profession.
Well, we do start referring to artificial intelligence, which is a good development for any textbook of any matter anywhere, because it's not going away. But as I'm teaching this semester, I'm reminding them that an article that I've written with one of my other co-authors, Joe Tiano, and I have decided law firms aren't going to be shaped the same way. At least big law firms aren't going to be shaped the same way when firms start using generative artificial intelligence more. They're not going to be a pyramid because they don't need the people at the bottom. Our message for law students then is you don't want to be the part of the pyramid that gets shaved off. So you need to be conversant in AI. You need to help the people who are still trying to remember what iPads do, how to use AI productively as lawyers. They need to become necessary to a law firm in order to survive whatever new shape law firms develop into.
Yeah, or to put it slightly differently, you need to be someone who uses AI rather than being replaced by it. And a lot of things that in the last 20 or 30 years associates were called upon to do are things that AI is already doing, reviewing documents, doing basic legal research, providing first drafts of briefs for common situations, a discovery dispute, for example. And all those things are important in that you need to know how to do them. But now what you need is to know how to do them with AI's assistance a lot more quickly and efficiently than if you did it page by yourself.
I'll also say that we get a lot of great feedback from adopters who are using the book. And one of the adopters used our unit on artificial intelligence to really make this point and have it hit home. He took some of the problems that we have in the book. He had students work through the problems on their own. Then he had the students pose the same problems to artificial intelligence and compare the answers that artificial intelligence gave to highlight where the weaknesses were, where you needed an actual human being, where the strengths were. And I think that's a really nice thing that you can do if you want to begin developing some of your students' competencies in using artificial intelligence, right? Garbage in, garbage out. You have to write a good input if you want a good output. But it also was really useful for that adopter when he was teaching to show the students why there's a duty to supervise, because the output that you get from the artificial intelligence, even if you write a really good prompt, was missing a lot of the nuance, and that needed to be added back in with the students adding their thought process that they had come to as they worked through the problems themselves.
Excellent. Well, we're obviously having to evolve legal education to deal with new technologies and AI, but also one of the significant changes in the last couple of years was the inclusion of the professional identity formation standard. And so does your book touch on that? And if so, please share how.
An entire book whose principal focus expositorily is to put the students in that driver's seat and force them to think about what if this were me is professional identity based. We also have a whole chapter and a number of interludes and other chapters about wellness and self-care and what you need to be watching for in yourself as time goes on so that you don't run into trouble, and what to think about if you see a friend or a colleague sinking someplace that you don't want to see them go.
On top of that, we have a chapter on the cognitive errors that even the smartest, most well-educated people fall into. And I think it's important for law schools to have courses like that talk about how our own brains will fool us into making bad decisions and then rationalizing those bad decisions. So our book is intentional in trying to help students think through what their professional identities are going to be.
And the purpose comes right out of the title, A Guide for the Well-Intentioned. We assume you want to do the right thing. And what we focus on is why that can be deceptively difficult to do in ordinary situations. You can be led astray by your own cognitive processes.
That's an excellent point that I think sometimes is lost in the teaching of professional identity formation. Well, thank you so much. And again, congratulations on the second edition being published of Ethical Lawyering, A Guide for the Well-Intentioned. You mentioned the title several times. I could see how intentional you were in in having that title, and it seems very apt for the book you've described. There are a couple of other things I'd want to touch on. Nancy, you mentioned when we were getting ready for this that you'd written a blog post today and that there's a lot of things swirling around in the news and some of them very pertinent to ethical lawyering. So did you want to share a little bit about that?
Sure. The blog post has to do with the law firms that are targets of the current executive orders by this administration and how different law firms have responded in wildly different ways to those executive orders. I actually brought the executive orders up in class yesterday, not to talk about the politics of it, because my goal is for no law student to ever understand which side of the political spectrum I'm on. And so far, I'm pretty good about it. But to tell them that when they are cash strapped or their financial existence is threatened, they're going to have to make decisions that may be different from how they think of themselves as a moral actor. And it was a reminder to them that when they are saddled with law student debt, they're going to make a different choice than the choice they might make when they pay off that debt. When it comes down to what kind of a lawyer do I want to be, financial handcuffs force your decisions in different ways.
It's very true. And I think most of the tragic circumstances that we see for lawyers who get themselves in trouble is exactly that kind of financial exigency where they think there may be an option that they shouldn't really consider. And Veronica, I feel like I would be remiss if I didn't ask you about your very new law school, Wilmington University School of Law. So share with us a little bit about this new law school and what it's like working at a fledgling law school.
Well, I could talk about this all day. You don't have to invite me twice. So we're really excited about our new law school in Wilmington, Delaware. We just got provisional ABA approval. So that's the first step down the road. Where we want to end up. Thank you. We are really, really excited. Our mission, to follow up on what Nancy just said, the finances of law school are part of the reason why students end up making some of the decisions they do when they graduate, and those decisions have a ripple effect down the line. We wanted our law school to be different in a lot of ways. One major difference is that it's very affordable, and we're committed to keeping tuition low. We have a very student-centric focus. That is a Wilmington University guiding principle, and we are a law school that is in line with the university. And our classes are small. Our professors have real-life work experience. We have real litigators on the faculty, real corporate law experts that negotiated major deals. And so far, we're really happy with the students that we're attracting and the success we've been able to achieve. We are trying to meet the goal that is quite difficult of being a law school that reflects the community around us, meaning in terms of the student population, in terms of the teachers, but also in terms of what we graduate. Not everybody is going to go work for the ACLU. Not everybody is going to be a Supreme Court clerk. Not everyone is going to go to a big law firm. We have huge, great corporate law firms in Wilmington, Delaware, of course, but also, you know what Delaware needs, just like every other state? Trust and estates attorneys, family law attorneys, public defenders, people who go to small law firms, personal injury lawyers. And so one of the goals of our law school is to reflect what is needed and what we have in Delaware as a community. And I'm really proud of what we've been doing so far. We're going to have our first group of students graduate next year and take the bar. That'll be the next hurdle. But so far, so good. We're really excited about what we're doing here.
That's terrific. What's the student body size right now?
We're pretty small right now, so we have a full-time program during the day, a part-time program during the day, which is sort of wrapped in, and a part-time evening program. Each of our class sizes has been roughly 15 to 20, some fluctuation day, evening, and the split. We are thinking that probably with the ABA provisional approval that there may be a change in the next cycle of applicants, but we're pretty committed to our goals, and so we didn't want to enroll students who we didn't think were going to be successful and meet our goals. There's no prize for size. I stole that saying from the former chairman of my former law firm, which then went on and absorbed a million other law firms. So much for that saying. But he did like to go around saying there's no prize for size. And we sort of have that ethos also at the moment at Wilmington. We're hoping to grow, but at the moment we're pretty small.
Well, that's exciting to start a school from scratch and sort of reimagine legal education in a little bit. We'll get to that in just a moment. But I did have one question since I have three experts in professional responsibility and ethical lawyering. I wanted to ask what you think about accounting firms being able to start providing legal services.
Well, I'll start with that because I actually had dinner with somebody from KPMG, and we were talking about the Arizona KPMG law firm. One of my big frustrations in law school is that we graduate lawyers who are afraid of numbers and afraid of reading balance sheets and afraid of thinking in financial terms. And when Arizona opens up non-lawyer ownership, it lets a big accounting firm slide in that already has that expertise, just needs to add the lawyers to it. I would love to graduate lawyers that are fluent both verbally and mathematically, because I think they will serve their clients better.
Excellent point. We actually just received a $5 million gift for a business and transactional law center. And I have the same view that I want to make sure we're graduating lawyers who are not scared of numbers. Veronica, did you have something to add?
Sure. I think that in principle, this is a great idea. I have a slightly more cynical view in practice, mostly because I spent most of my career at the U.S. Attorney's Office handling False Claims Act cases. And it seems to me that if you want to see an example of what happens when people who are not in the field manage the industry, you can kind of look at the healthcare field. So I do think that there are reasons why this could be successful, why it's a good melding of skills, why it could serve clients well. I do think, though, that there needs to be some lawyer management up at the top because going back to professional responsibility, the obligations are different for accountants and lawyers. And I think it's important that the people who have the voice in steering the business are taking into account those differences.
Yeah, and I think it's fair to say that the jurisdictions that are thinking about opening up non-lawyer ownership or non-lawyer partnership have adjusted their rules in ways that emphasize the independent ethical judgment of a lawyer in top management. If I could indulge for a second in speculating about the future, my view has always been that artificial restrictions about who can sit next to you and maybe share profits have never been a particularly good idea and are ultimately or initially were guild protective to start with, which isn't a particularly good idea for clients. But so making more legal services available to more people is, generally speaking, a public policy goal that we should all support. I personally don't think it's going to make a heck of a lot of difference. People who are talking about it revolutionizing practice, I think that's really overstated because the big accounting firms that are starting to do this are going to compete to some degree with the big law firms. But something like 75 to 80% of the practicing lawyers in the United States just don't live in them. And it's not going to change what they do pretty much at all. I don't even think that there's a significant increased risk of bad acts in a Price Waterhouse law or a Deloitte law, simply because big law firms stumble into those problems with the same frequency and to the same degree, so far as we can tell, as accounting firms do in the things that they currently do. Big institutions can go astray, and these will be more big institutions that will go astray in pretty much the same way that lawyers already do.
Well, thank you for indulging me in answering that question about that recent development. Before we conclude, I wanted to ask each of you what your predictions are for the future of legal education in the coming decade. And maybe, Bernie, we can start with you.
I'm completely of one mind with Veronica. We spend entirely too much time collaborating, I think. That there is legal education has wandered since the 1970s away from a practical law practice model. And we've already started gravitating back for the practical reason that starting with the Great Recession, the ability to get a job after law school became much less certain and therefore much more of a preoccupation among the people who were attending law school. And what they're doing for the most part is trying to prepare themselves as lawyers, and that means they need to get as much insight as we can provide them in 3 years into how lawyers do what they do. You can't obviously turn out a fifth-year associate starting from the ground up, but you can put someone into a practice situation where they are prepared to anticipate the tasks that they will initially be asked to do and the environment they're likely to be in. Veronica pointed out, we're already headed that way, and I think that will excel.
Veronica.
I think that legal education is going to become more compact and skills oriented, meaning fewer sort of bird law electives and sort of esoteric one off fun things. Not that law school in general won't be fun, but a lot more oriented around what are the needs of the practice today and how can we give students skills that are portable. So they might learn it in the context of their favorite bird law class, but it's really about learning how to write artificial intelligence prompts or learning how to consult with clients or learning how to work with accountants. Whatever it is going to be much more skills oriented. That's my prediction.
Nancy, you want to bring us home?
Absolutely. I'm going to harp on AI again because in addition to all the benefits of learning how to work with AI that students are facing, I don't think that the professors have figured out what I'm going to quote the Barbie movie and What Was I Made For? What parts of the way I teach are uniquely human and uniquely important, and what parts will AI be better at than I am? So I think just as the students are going to cope with that, we need to figure out how we're going to cope with it too.
That's an excellent point. Actually, the first time somebody has brought that up from the professor side. Well, I want to thank you all so much for spending some time with me, Nancy Rapoport, Veronica Finkelstein, and Bernie Burk. And congratulations on the second edition published through Aspen of Ethical Lawyering, a guide for the well-intentioned. If you have enjoyed listening today, I hope that you'll listen to additional thought leaders on the Aspen Leading Edge podcast that you can find on their webpage or on your favorite podcast channels. Thank you.
Thanks.
Thank you.